we have an hour and a half for this particular panel, and we are also live streaming, and we have some folks participating from the law school. So if we will turn it over to audience questions at any point, and also we'll take questions online as well. So this year the theme for World IP Day is IP and Youth, Innovating for a Better Future. So I want to share a little bit about our school's involvement in this topic. Really, from the time that we were founded, we were focused on being kind of the IP law school. That was the goal of our founders, to create the law school for the information age before anybody was calling it an information age. And from the founding, we were really committed to increasing access to STEM education and encouraging young people to be in the business of innovation and part of that ecosystem. Our founder, Robert Rines, had a variety of talents, including he often searched for the Loch Ness Monster. But he founded the Academy of Applied Sciences, which brought STEM education to kind of K through 8. And he created, as part of that, there's the Young Inventors Program, which still exists across the entire state of New Hampshire now, and my 9-year-old in 3rd grade is working on, as part of that program, they work on different inventions. So his invention, Kevin Carroll will appreciate this, his invention this year is a cast that will, for your arm, that has heat inside to help sort of the healing of bones. And he probably will be looking for a patent attorney, so just getting that out there. We also at the law school started an undergraduate minor in law to try to expand legal education to younger students and include sort of access to increase that pipeline, including at the College of Engineering. And when it comes to law school, when we think about innovating for a better future, we are really focused on diversifying the legal profession and making our top education in IP accessible to more people who otherwise wouldn't be able to get it. We created the hybrid JD. It's the first in intellectual property technology and information law. It's the first ABA-approved specialized law degree in the country, and we're really proud of the fact that it is focused in IP. The diversity in that class and in the incoming class, I believe this fall, is at this point at about 40%. There are lots of moms with young kids in the program, and it's really incredible to see how this kind of program that, if you limit law school to people who are in a position to quit their job and maybe sell their home and move and take out a bunch of loans to pay for law school, you're really limiting that to a very narrow segment of our population. And there are people who will be great lawyers, and it's incumbent upon us, and we take it very seriously, to make legal education accessible to more people. In the last 4 years, we've increased the students of color at our law school by 4-fold, and we're also proud of that. But sometimes as we look at the stats for the innovation ecosystem generally, the statistics are not great. Women make up a smaller share of the workforce in IP-intensive industries, about 43%, than in non-IP-intensive industries, which is 54%. Women are commonly cited statistic. Women are about 18% of patent lawyers. And while the Asian population is higher in IP-intensive industries, Black and Hispanic population is higher in non-IP-intensive industries. So as we think about innovating for a better future, the economic impact of IP is something that we need to be thinking about, and is one of the most important components of that. So in the 1990s, of course, companies, spending by companies on intangible assets started to outpace tangible capital assets, and so by 2004 or so, Alan Greenspan was declaring we are in an IP economy. And now a recent report from the USPTO, following on the heels of the 2016 report on IP and economic activity, says that IP-intensive industries now have gone from 38% of our GDP to 41%, and jobs in IP-intensive industries now count for 44% of all U.S. jobs. This is great, and we talk a lot about this with our students, especially our prospective students, because jobs in the IP economic system are more likely to earn higher wages, work in larger companies, have benefits and retirement, and be more highly educated. So with that kind of general scene setting, I'm going to tell you a little bit about what we're going to do this morning. I am so pleased to welcome an esteemed panel of experts to talk about this topic, the economic impact of IP in various ways. So here's what we're going to do. I'm going to ask them to introduce themselves. I know that we all know one another, but for the people joining us online, I'd like to go down and have each person give a brief introduction. And then what we have done is to select a slate of 5 individual topics. So each panelist is going to introduce a topic and talk about it, why it's relevant to innovation and the IP system, what the economic impact is on innovation, and then other panelists will share their perspective on that topic as well. And throughout the conversation, please feel free to interrupt with questions. Is that okay? We can interrupt throughout with questions and comments and be part of that dialogue. Because you all here are not mic'd, I will be repeating your questions, so that's why it's going to sound, it will sound repetitive, but that will be for people who are joining us remotely. You can also throw rotten vegetables or protein bars or whatever you have if you like. So we're really excited to do this, and I value so much what we have done so far here, and am looking forward to continuing that level of thought-provoking conversation. So the topics we're going to talk about this morning include the connection between patents and innovation, 101 issues. We're going to talk about COVID waiver, getting young people involved in STEM, and because we really can't resist, we're also going to talk about the New York Times editorial that came out a couple of weeks ago from April 16th. Okay, so let's, Bob, would you like to introduce yourself first, and we'll just go right down the line.
My name's Bob Stoll. I'm a partner at the law firm of Faegre, Drinker, Biddle & Reith in Washington, D.C. I am also the deputy chair of the IP group, and I spent most of my career at the Patent and Trademark Office, starting off as an examiner and working my way up to be the head of external affairs, which handled legislation and international issues, and then ended as the Commissioner for Patents in the United States Patent and Trademark Office.
Jonathan?
I'm Jonathan Stroud. I'm the general counsel of a company called Unified Patents. We're a defensive membership organization, and we also have a trademark enforcement business and a patent pool and some other interesting side businesses. I was a patent examiner for 5 years before I went into private practice at Finnegan, and then made the leap about 7 years ago to Unified. It's been an interesting position from which to sort of see what's been happening in IP, although obviously much more recently. I always feel like I have to say how honored I am to be in these rooms and how happy I am to be amongst who I think are as friends now, but who clearly have had much longer and more impressive careers than me. And
We're just older, John.
Well, that's it. I'm turning 40 next week, so
Baby.
yeah, it's approaching like a freight train. So I'm happy to be here. Thank you.
Phil?
I'm Phil Johnson. My background is training in biology, biochemistry. I was also a theater minor in college, which led to me going into private practice. I was in private practice for 27 years, originally prosecuting patent applications, but quickly developing trial interests and became a lead trial counsel, doing bench and jury trials and other things until one of my clients, Johnson & Johnson, recruited me to come in and become chief patent counsel at J&J. I spent 17 years at J&J, and during that time, beginning in about the mid-2000s, became involved as a policy spokesperson for not just for J&J, but for a coalition called the Coalition for 21st Century Patent Reform, of which I'm still the chair of the steering committee. During that time, I testified before Congress as an expert on patent issues, I think about 10 times in front of the House and Senate Judiciary Committees. I was named by the minority whip as one of his kitchen cabinet members for the AIA. Thereafter, I was one of the experts chosen by the Bar Association, IPO, joining 5 other experts at the request of Director Kapos to develop proposed regulations for the AIA, which we did. We made a submission, which you can find on the USPTO website, laying out what the 6 experts and the Bar Associations thought should be the way IPRs and PGRs would be implemented under the AIA. And proceeded after that to stay involved in IP policy matters until I retired from J&J in 2017, when I founded my current consulting practice, which specializes in strategic advice, and I also do some expert witness work.
Phil, you forgot your, I think one of your biggest accomplishments.
One of my biggest accomplishments is that I have a daughter who graduated from Franklin Pierce, who's now head of IP strategy and policy for Amgen. Is that what you had in mind?
Yeah, and then your second biggest accomplishment is that you are an honorary degree recipient. So you are an honorary graduate of our school as of 2021.
Yes,
so.
that's true.
Thanks, Isabella.
I'm Isabella Fu. I'm Chief Patent Counsel at Microsoft. Previous to that, I was head of litigation at Intel. Most of my career, I've been a litigator, but more recently, I've been focused on non-litigation IP issues, patent issues. Before that, I was in private practice doing all types of IP litigation and licensing. I'm not going to list all of the honors that I have received, but I will note that my son says that I am the best mother in the world.
Wow, I don't know if I can top that. My children would not, well, my children might think you're the best mother in the world too, so. So, hi, I'm Kristin Ozinga. I am an engineer. I say that like an alcoholic. I'm an engineer. So I have a bachelor's degree in biomedical engineering, a master's degree in electrical engineering, and then I went to law school. And so after law school, I worked at Finnegan Henderson, another alum with Jonathan. I clerked for Judge Lynn on the Federal Circuit, and then I went into teaching. So I've actually been at Richmond now for 16 years. I teach patent law and antitrust, and I'm raising 2 sciencey kids, which is pretty darn cool. 2 sciencey girls who want nothing to do with law. So maybe I've succeeded or maybe I've failed. I'm not sure which that is.
Yeah, for now.
For now.
I didn't want anything to do with it.
Well, there you go. I may end up with 2 lawyer science daughters yet, so.
Thank you. And I'm Megan Carpenter. I'm Dean of UNH Franklin Pierce School of Law. I started my practice at K&L Gates, and which was K&L at the time, and then focused on building IP programs at different law schools. For me, then it's just an enormous joy to be able to combine 2 things that I absolutely love, education and intellectual property in situations like this. And I recognize that, you know, my practice experience is so long ago now that the students don't need to be learning from my, you know, old stories and war stories, and that it is an incredible experience for them to be learning from people like you all, and so it is such an honor to be able to see the students and all of you come together at events like this. So let's have Jonathan kick us off. We met, and Jonathan wasn't there at the beginning of the meeting, which means that he was voted to go first. And Jonathan, can you talk to us a little bit about the connection between patents and innovation?
Sure. So innovation, so we're focusing on patents, right? So innovation is a term that gets thrown around a lot that's hard to define, but everyone loves it and everyone wants more of it. And It's very important for the U.S. economy. And the U.S., to be clear, has been a leader in terms of industries that have innovated, that the other world has followed suit. And it's generated a lot of wealth for those companies. It's generated a lot of wealth for the U.S. economy. And it has, more importantly, I think, hopefully, and this is the goal of patents, it's sort of in the Constitution, and it's one of the geniuses that was sort of buried in the U.S. Constitution that has taken on a very important life of its own, was to encourage everyone to share, right? Everyone to share their inventions. I'm trying to tie this to our standard essential theme for this week. Pre-patents and sort of modern economy, right? You had cabals of inventors. There's these famous stories about Venice and early London where the inventors would jealously guard their secrets. Monarchs would jealously guard the color that they found a formula for, and they wouldn't share it with other monarchs for 200 years, right? And it impeded progress because there was so much value in this IP. And so the founders and people before them in England and in Europe envisioned a system where you would lay all of that bare. You would tell people exactly how to make it and exactly how to do it. And in exchange for some economic benefit over some short period of time, you would share with the world that progress and the world would move forward. And when the system works, it works wonderfully, right? You have companies basically going to the government to disclose their secrets to help everyone in the world move forward. When it doesn't work, right, when there's poor notice or when the patents are poorly written or they sort of become investment vehicles or something else, it becomes more of a sideshow than it is sort of the driver of that innovation. But when it works, it works well. And I'll give you one example. When I was an examiner, and I'll preface it with, I saw a lot of applications that I don't think ever should have been granted. I mean, I think there's a lot of economic value in it, so a lot of people will apply for patents. But there was this one guy who came in, and he had a client who had taken this biomaterial that was a ceramic that people had known about. I was a biomedical engineer too. And he had put it into hip implants, right? And the material was known. There were patents out there on this being used as ball bearings for machine parts and all of that. But I couldn't find any evidence of it being used for biomedical purposes, right? And the patent was very well claimed. It was claimed where you knew what the material was, you knew the material properties of it. It was sort of rare in patent practice for being kind of clear about what it was saying. So at first, like a good examiner, I made the argument that it would have been obvious to do that, and he came back with a declaration demonstrating that this was unexpected, showing evidence and data, and on balance, I thought he was right. You looked at the case law, and you looked at what he did, and this inventor deserved a patent because they had been kind of pioneers in discovering this unexpected use for this known material. He got that patent out of me, which was apparently hard to do if you look at my statistics. And I didn't think about it for 7 or 8 years. And then I was in private practice, and I was bored one day at work, and I looked the company up, right? I looked the patents up first, and I found the company. And the company went on to get a few other patents in this space and launch basically an entire company with an entire line of products based on this innovative idea that was relatively successful. They're not a huge company, but they're a moderately successful company. And then I ran into the prosecuting attorney years later at a conference. It was about 6 months ago, and I wanted to shake his hand because I said, that was the system working the way it should work. We had a company, someone had a good idea, legally, once it was stress tested, it made sense. They got the patents, and they used that to generate wealth for their company, to help share that invention with other people. It was a more successful biomaterial than a lot of the competitors won in the marketplace. Unfortunately, I think today that type of story is more the reason I remember it, right, is because it's the exception and not the rule, right? A lot of the patents that people were applying for and that people do apply for, massive portfolios, as we know, right? Continuations that go on forever. a lot of patents on what is essentially a single idea or a single invention. But they can generate through continuations and through continued payment to the offices. And now there's a lot of, let's call it noise around the core of the idea. And so there's always this debate that goes on in patent spaces about whether there's too much or too little patenting, or too many grants or not enough. Obviously, there's a lot of utility when the system works, and it drives innovation forward. And I want to stop and say, patents are just a small piece of that, right? If you look at the three richest people in the world, right? Elon Musk, very successful, a lot of innovative companies, a lot of patents cover what they do, but also a lot of it is, he's leading the marketplace despite patent protection. Number 2 is Jeff Bezos, obviously. Number 3 is Bernard Arnault, right? Bernard Arnault runs basically a coalition of brands, right? Louis Vuitton, Hennessy, others. There's more value in those brands and in his personal wealth than there are in Facebook, in Google, in a whole host of other companies, right? Brands and trademarks drive a ton of that. And a ton of the IP-intensive industries that we talked about are primarily dominated by copyright protection and not patent protection. So when we talk about IP being important, it's all forms of IP, and patents play a very important part in that conversation, but they are obviously not, like anything, the silver bullet to all of our economic woes. Otherwise, we would be at the forefront of everything and in every field and all of that, because I do think we have the best patent system in the world, and we'll continue to have it, although, of course, there's always things that you can do to change.
Who else would like to comment on that?
Well, I would agree. I think that when the system works, it does work well, and no system that is based on deciding whether something is a non-obvious advance over what's already known is going to be completely 100% predictable, because opinions differ about obviousness. And as hard as we've tried, and as hard as our judges have tried to clarify things, you're always dealing with something new when you come up with an invention, and therefore there's not precedent strictly on point. But I do think that by and large the system has served us very well for now centuries. And it has some problems, and I'm sure we'll get to some of those problems, and it has some things that could be done to improve it. But I think there's no second choice but to have the patent system that we have.
So I'd like to comment a little bit as well. I agree with Jonathan that we have to think about all forms of IP. It's not just patents. There's, trademarks are incredibly valuable and also incredibly important just for things like if you think about, Amazon or, eBay, why are those so important? Because, as from a consumer standpoint, you want to know what you're buying. And in fact, a lot of those very trademark intensive industries also rely on innovation. It's a trademark that signifies that, they've got the innovation in their product. I do, because we're talking here at a law school that's focused on IP. I think back to, the educational system in the United States and a lot of the world and what we learn in law school. And I think there's an overemphasis on the proprietary nature of IP rights. I mean, they are intellectual property. That's appropriate. But we should think about innovation, more generally, and think about how IP can hinder as well as promote innovation, and particularly in sharing. And one of the things that I think we're thinking about now in terms of AI and some of the biggest problems we have today, which are things like climate change, the pandemic, cybersecurity, again, use of AI both for good things and bad things. One of the things that we have to think about is, what we can do with data and what we can do with AI and ML to solve some of these problems. And the fact really is that the use of data and the sharing of data is really, really, really important for that innovation. And what we see now is in some countries, and in the United States, there isn't really protection for data as an IP right, but more and more, there seems to be a movement towards thinking about whether or not data should be protected. Either amassing a large amount of data or the collection of data and that sort of thing. And I would submit that we really should think really carefully about that, and the notion that protecting something necessarily drives innovation as opposed to the sharing of something that might also drive innovation. And, again, for things where we have these massive, massive, massive problems, the sharing of data is going to be really, really important. I think we've seen that more and more, with respect to COVID. Microsoft spends a lot of time sharing data sets, allowing other people to share data sets, of course, within the confines of, confidentiality and privacy. But it is one thing that I think that our law schools have to think about more is how much open innovation there can be. It does use IP constructs, but in different ways than I think we're traditionally thought, which is about exclusivity as opposed to sharing.
Isabella, have you seen that tension between kind of a proprietary approach? I mean, as companies move in directions that are less proprietary, does that create some kind of tension? Have you seen that in your practice over time, or is that a more harmonious relationship?
Yeah. I mean, I think there's tension even within a single company, because I think there's always debates about, should there be patents on, computer-related inventions, that sort of thing. And there are inventors, at the company who strongly believe in patents and want to patent everything. And then we have other engineers who really, they believe in open source. They're, kind of against patenting. We have to explain that, simply because we're going to donate something to open source doesn't mean we won't file a patent, because a patent covers more than an implementation. There might be real reasons that we want to do that. In other words, sometimes you have a patent with respect to a standard or an open source because you want to encourage people to use the solution that you have, and you do that by creating a license around those patents that drive certain behavior. You can use this for free, but there's also some restrictions about it, right? And so we definitely have tensions within the company. There are many different models, right, to stimulate innovation and to share innovation, but also to protect innovation. And so there's absolutely tension among the employees. There's tension in, really every project in thinking about what is going to propel the innovation the most.
Yeah.
So I'd take it in a slightly different direction. I agree with a lot of what's been said, and this is a very strange direction for me to take it because I very strongly believe in the patent system, very strongly believe in patent rights, but I think one of the things that sometimes we forget about with respect to innovation is a lot of really great innovation isn't driven because there's a patent system. And so I want to take you back in time. We heard yesterday more than once about the 1904 Baltimore fire and the standards, and that was a problem and what have you. But there's another interesting piece of that story that I've been digging into the 1904 Baltimore fire for absolutely no reason whatsoever, except I got down a rabbit hole. But what was interesting is while the fire was raging and the fire trucks from DC and Philly were just sitting there completely idle because they were unable to hook up, we saw this extraordinary amount of innovation because a guy in a machine shop started building bespoke couplings so that he could hook these the fire trucks from DC and Philly up to the Baltimore hydrants. Now, standardization would have made everything a lot better, don't get me wrong, but a lot of times when we see really incredible innovation is when we are seeing somebody solving a real problem. And that's not about the patent system, that's about something there's a problem to be solved, and it's really fantastic when we see that.
I too read about I went the same rabbit hole you went down. But what I found interesting was that the standards weren't universally adopted in the United States for over 100 years.
And still haven't been.
And still completely have not been. And there have been other fires in other cities where the same problem has occurred.
Yeah.
So I found that very interesting. I do think we forget about trade secret a lot. And everybody, especially in the era of 101, and I'm not sure how I spell era on that one, you'll find that a lot of people decide to protect their stuff by trade secret, which is a completely legitimate form of protection. I just think it doesn't really move forward the ball very much. So I wish we would find a way to bring that trade secret to the public while protecting the people who develop it. And I think that's something that we should think about as a society. I'm a strong advocate for patent protection as well. I think that's very important. But in many of the discussions I've been involved lately, I think there is a strong interest in some sort of sui generis right for data. I do think that there is a movement internationally because that's going to be extremely important in training AI to develop future inventions. And I think that there is the beginnings of discussions to see whether or not we can find some sort of right that way. I am going to get into my speech with respect to the quality issues, and I've always found that quality is my patents are good and your patents are bad. And that does seem to be something that's happened. And I've also seen where I've been testifying in certain cases where they want to bring in a second IPR with a brand new, newly found reference. And of course, you don't have to have scorched earth, so you can do that if you can find it. Well, if companies are going to spend 40 hours and zillions of dollars to find a reference, I mean, that kind of changes the entire game. And I think we need to think about that as well.
And on the data point, I want to mention too that seems at first like it might be something that's limited to a certain subset of companies, but that has started to infect is not the right word. Every company, in terms of a major consideration, every industry that you can think of. Like the way that the COVID vaccine was developed was based in large part on databases. And a lot of those were created by the government, or the government assisted, or the Genome Project helped. But there were computers that were helping to compute what the drug would look like, right? And that shaved off years of drug development. And so in other industries, computer-generated models, data sets that someone has built over time that took a lot of time and a lot of effort and a lot of energy, but that nonetheless, it would be better for the world if they were shared, or at least you could purchase access to them or something, is going to be, I think, the next forefront of the debate, because it's how do you incentivize that without, and you want people to share it without destroying all of the time and energy and effort that they put into it, just like the patents.
Agreed.
Jonathan, do you think your work with Unified, has that changed your perspective on innovation and patents before?
Yeah, I think there's no way that your where you sit can't on some level change your perspective. I mean, when I was at Finnegan, I was working defending IPRs for a pharmaceutical company that had a patent that was under Hatch-Waxman attack and some generic attack the patents. Those patents actually ended up surviving on secondary considerations, as they should have, because they were innovative. But then, you go over to Unified and you end up mostly on the challenger side, and you see, we tend to operate in a space where people are asserting very, very, I would say, very thin patents, or things that probably, if not never should have been granted, at least have claims that are overbroad. I think it's generally understood that there's something that, but it's like the drunk who is looking for his keys under the light, and somebody comes by and says, "Hey, what are you doing? I'm looking for my keys. Did you drop them there?" "No, I dropped them over there, but the light's better over here," right? We're all focused in our own little tiny skull-sized kingdoms and our own little areas of the law. So I try to take a broader view than that. I mean, obviously there are 1,000 different ways to come at this, and there's a lot of people that the system hurts and benefits at the same time in very different ways, in very different industries. And it's something that you sort of have to accept that there will be problems, and accept that there will be wild successes and things that make a lot of sense. So I don't know if that's a unique perspective, but I try not to be too focused on the bad patents, although I think that's inevitable. And I think if I was at a branded drug company for 7 years, inevitably I would be like, these are, and they would be, because you'd put all this time and energy and effort and money into them, and it would represent the hard work of a lot of people, that you would be very encouraged by the successes that you'd seen in the system. So I think that there's a lot of perspective that goes into how you look at IP.
Yeah.
Well, in several people's comments, even just in the beginning of this panel, it's things have come up time and again about whether the system is broken or not, and where it works for some purposes and not others. So it might be a good time to talk a bit about the New York Times editorial.
Sure.
Bob said he could talk about anything.
Yep.
So
Well, I've read the New York Times article several times. I do not find it persuasive. I actually think it's been debunked quite effectively by both the Chamber of Commerce in the United States, and I think Adam Mossoff wrote a nice piece that explained that the basis for their facts was not completely accurate. But there are pieces of it that I think that, as there are with everything, that should be considered. And I think that the overall thrust of the article was concerns about the quality of the Patent and Trademark Office examination and issuance of patents. And actually, I was responsible for that for a couple of years, so I can tell you a little bit more from the inside about what's going on. And I will acknowledge that I believe that the quality of the patent that is granted drives everything. I mean, it literally drives everything. It drives your PTAB analysis, it drives the marketability of your subject matter, it drives the companies that are able to rely on it, so I think it's extremely important. That being said, probably less than 1% of all the patents get litigated in any way, shape, or form, and so we as a society need to do a balancing act about how much effort to put into the examination vis-a-vis the value that comes out where only 1% end up getting litigated, and nobody really knows what that 1% is. Now, let me first start off by saying I think that there's a misperception with respect to the quality of the examination that's done in the United States Patent and Trademark Office. I undertook several studies and did comparisons between the JPO, the United States Patent and Trademark Office, the Korean office, the Chinese office, and all of the big 5 offices that are around the world, and found that the quality did not significantly deviate. What did change was the references that were used in the applications. And my analysis found that most of the references used in the USA were US references, and most of the references used in the EPO were EPO references. But the outcome determinativeness of what happened was usually about the same, and I mean very close in the analysis. Let me say also that quality is kind of a lagging indicator, and it's also initiated by what comes in the door. And I find that there is a differentiation between the types of patents that do come in. I find the applications coming out of the pharma area are usually a much better quality than come out of some of the other areas. One of the reasons is that they have limited numbers of patents that are going to be valuable, and these drugs, the patenting process is not what's really costing, it's the development of the drug and the approval of the FDA. So they're willing to put money into the drafting and prosecution of those applications. Many other companies are going to the least common denominator. They, pay $5,000 or $6,000 for the drafting of the application. Or less, but not a lot less. I mean, but that's the problem. And I think that, you get these crappy applications that come in the door. And I think that's a problem. I think most of the large companies now are becoming much more sophisticated and are recognizing that they're going to file probably fewer patent applications, but the quality is going to improve so that they can actually take these to the bank and use them. And I think that's an important methodology. The cases that come out that affect the prosecution, you've already got applications on file that are subject to these new laws during the prosecution of your applications, and you can't do much about it because you're limited by the original scope of your specification. So all you can do is change in the future, and if you want to file a CIP, which I would never recommend, you can do that and add new matter to your specification. I think that that's a big problem. I do think the examiners are very interested in making sure they do a good job. I don't know if people on the outside recognize how hard they work. You said you had a low allowance rate when you went, I was 34%.
26.
Oh, but all right, but I mean,
thought I was high. When I looked it up, I was shocked.
Varies depend upon the subject. I was
definitely.
inorganic compounds and metallic alloys.
Yeah.
And you know, they're out there. I had the oldest patent in the United States in my shoes, and it was for potash. But I really think that they tried to do a good job and work very hard to do it. I'm not sure whether we need more time or not. I mean, that depends upon what society determines that the valuation should be. I would recommend we do give a little bit more time, but more important to me than that is that the applications coming in the door are thoughtful and accurate and good applications. And the second thing, and I think this really drives the examination process, is the search. And what I think is very important, a lot of people, the United States is unique in our Rule 56 obligations, which requires the applicant to provide all the information of which they are aware that is material to the prosecution of the application. And that's because usually the company, the prosecuting attorneys, and the inventors know what is the best, closest prior art. And I think that's important. The other piece that's important is making sure there is access to all of the commercial databases you can possibly get. And I will acknowledge that the PTO could still do more databases, but it is a wealth of information there at the hands of the examiners for undertaking the examination. I do believe that there is a differentiation. I have a hard time in, I guess I can say it, in 3600 for myself, and it's not the newer examiners that are a problem, it's sometimes the older examiners who are recalcitrant. I see Jessica laughing in the background, who don't want to change the way they do things, and that's a problem. But there are other areas. I do believe we had a big problem when we went into software. I think that was something that the Patent and Trademark Office was not capable of doing a good job on. The same thing happened when we started prosecuting biotech type patents initially. We didn't have the databases, we didn't have the skilled examiners, we didn't understand what was new in that particular area, and we were being flooded with thousands of applications from the financial industries who were scared because of State Street Bank and wanted to protect themselves. So I do believe also that over the years we got better and better and better, and that's why covered business methods is no longer needed anymore and it's sunset. I think what happened was we developed some skill in that area, and now it's parallel to the quality of a lot of the other groups and areas. And with that, I'll hand it off.
So I would add a couple things. So one thing that I should note is that I think Bob was my boss's boss's boss when I was at the office. So I have to be careful what I say and how I criticize the office when I was there. I agree that the examiners do their best and are trying. I'm sort of a procedure and numbers game guy, and I think there are things about the United States system's prosecution that are unique around the world. And the low-hanging fruit that I think companies actually don't want to get rid of, but I personally, speaking in my own capacity, would, is I hate endless continuation practice. And I know that there are directors in the past who've tried to get rid of it or change it. There are so many entrenched interests against it, but you can effectively just keep paying to keep trying. And eventually you wear the examiners down. I have gone back and looked at patents where I rejected it the entire time I was there for 5 years. There was nothing in there worthwhile. The guy was trying to play games, that was trying to prosecute it, multiple continuations. I leave, it gets transferred to someone else, and lo and behold, they got an allowance out of it, right? And I think that there's a fair amount of portfolio buffing that happens that isn't really great for the system. It just serves as a business wedge. So if I could magic pen do that, I don't think it will ever happen. But the other thing that's been happening that's really interesting, and I think this has been happening for 20 years, is as we moved into the 21st century and we were talking about the bridges of humanity and the arc of the moral universe and normalization with other areas, we adopted what was effectively the world's patent system, right? A lot of international applicants came in through treaties, and today, if you look at the top 10 patent getters every year, I think 8 of them are foreign companies.
Well, IBM's number one.
No, it depends on how you look at it. Samsung is very close.
They're
like
number 2.
30. And if you look at the number of total grants that they have or applications or something, I think Toyota is either Toyota or Honda is number one, but they're all close. I mean, it's a tight band. And so a lot of US patents are being granted to foreign companies, which is fine because of how we look at treaties and how we treat the system as neutral. But it's interesting against the backdrop of Russia pulling out of some of these treaties and doing things that aren't okay, and some of the national efforts at the PRC to sort of, there's been abuses that have been found where they went to our trademark registry and flooded people with applications. I'm sure that there are similar things that may happen in the patent space. And so I think that it's important to you look at that too, right? There's sort of a new national aspect to it that we have kind of had blinders on for a while about.
There are various reasons why continuation practice is beneficial. First of all, you see some of the criticism that's been leveled is that there isn't enough time for the examiners to really do a good job in examining an application. And continuation practice allows more time, doubles the time at least that the examiner can consider the technology. Another important reason is that for important patents, they're often filed and prosecuted around the world. And therefore, the art that was mentioned that tends to be cited in Europe and Japan and other places that isn't cited here is something you become aware of. If you have a patent that you think is important and you think may be challenged, you want to be sure that you get all of the art in front of the U.S. Patent Office in a timely way with a record that shows that it has been completely considered, so that you aren't as vulnerable if and when you need to assert that patent. That's particularly true if you have a long development time product and you don't really need your patent out because you don't have a product on the market yet, which is particularly true in the pharmaceutical industry, where you may have 10 or 12 years from the time of original conception until the product comes out. So those are just some of the reasons, but other reasons are that while legislation tends to be forward-looking, decisions of the courts are not forward-looking. They proclaim what the law is or explain what the law is, and it's applicable going backwards. And you see in some court decisions, courts saying, well, it shouldn't have been drafted this way, or no, that wasn't the way it should be claimed. If you have a continuation pending, you can respond to an unexpected court decision and redraft your claims along with obviously, the supervision of the examiner. And you can get claims that are not subject to something that was perfectly suitable at the time you originally wrote it, but now has become verboten as a result of a court decision. In the end, the product is a product that will serve the functions that we've said products should serve. The claims may be narrowed, but I would not argue, as long as the fees are paid, and the fees should cover the work, that it's a bad thing per se to have continuations. And as for examiners, I don't think anyone who knows Jonathan thinks that any number of continuations would have worn him down. And I think that's true of many of the examiners. I'll also say I think the examiners are sometimes not respected as much as they should be, because you have dedicated professionals who become super experts in a given area. And they can, in my experience, and when I was prosecuting, you could go to one of these examiners who was highly skilled in the area and show them, if you will, your invention, and in 5 minutes they could tell you whether or not it was likely patentable. So they may have 19 hours to do the paperwork, but people tend to belittle the expertise that they have because they spend their careers focusing on a very well-defined area. And I think they may not know everything that's known in the world, but they are very good within the bounds of what they know.
Yeah, if I could respond to that, I agree that the examiners are doing a fantastic job with the time they have and the resources that they have. And Bob makes excellent points about the quality of the drafting of the applications. I do think that companies that care about their patents, they do spend more time and money on their applications. The problem is the abuse by those who actually do not want a clear patent.
Yeah.
And that is actually a huge quality issue that goes beyond validity. And so I think we focus a lot, and we rightfully should, on, can the examiner find the right art? But a huge amount of litigation is really actually about what do the claims mean, and we're not really equipping the examiners with the tools to make sure that the claims are really clear. So, in Europe, most of the multinational companies now, they prosecute patents all over the world, and we do too. And in Europe, it's much stricter in terms of, how do you draft your claim, and is it actually shown and supported by the specification? And there are rules that we could change, in the MPP or the patent examination rules, to put more burden on the applicants with, no really more cost, but to actually make sure that their specifications match their claims, like they do in Europe. There are other things that we can do in terms of the back and forth between the patent office to make sure that what the examiner thinks that they're agreeing to, because I think the examiners, they do look very carefully at the prior art, and they try to get admissions, sometimes from the applicant to say, my invention is different from this prior in this way, but then the claims aren't amended, or they're amended in a slightly different way, and then there's a big fight about did they really disclaim something that was in the prior art or not. And it's, even the Federal Circuit, I think, has trouble looking at the back and forth between the patent office and the applicant to figure that out. And, with 19 hours, that's going to be really difficult. And, on the flip side, you've got these these prosecuting attorneys who are spending way more than 25 hours, and you see treatises written about basically how to get around, these disclaimers. And so I think we need to really look at the rules and make sure that the examiners understand, that they can read this document, know what to search for, because that's another big issue. You often start with these very, very broad claims, and it's difficult for the examiner to search on those claims because they are so broad. And so your whole first, wave of examination is almost a waste until they start to narrow the claims, and then you can do a real prior art search. But it's a losing battle for the examiners with the process that we have now, and I think we really need to change it. And I would say also that it doesn't place any more burden on the applicant to make that clear in your first application. They know what they're going for. They just need to write it down, and then they need to be held to it. And I think with that, I don't know how much more time we need to give the examiners. There is more time given in other countries. With the fact that only 1% are litigated, there is a question. You don't want to spend 100 hours, I think, on each application. So I think that's a good question. And I think that a lot of the companies who spend a lot of money on patents are willing to pay more fees. And I think they should look at the fee structure. Right now, it's all back-end loaded instead of loaded at the examination time and the issuance time. So I think that could be changed. And we don't need to change the fees for the small entities, the micro entities. Those can remain the same because those are a relatively small number of patents versus, the companies that can really afford to pay. And given the amount that the companies are paying to draft these applications, like a little bit more an examination fee, I think is well worth it. I think everybody wants to know that their patents are valid. They also want to know what they mean. Even when you draft a patent really carefully and you go to assert it, there's always fights about what your claim means, even if you do the best job you can, just because of the current state of the law. And that's unfortunate as well. But more and more, I think we need to stop the abuse, because I think most companies use the patent system in a way that it's intended to be used, or they want to use it that way. But unfortunately, I think, given all the gamesmanship that we see, either from other nations or just folks who, just up to no good, we have to make the system a little bit better.
Go ahead.
Over the course of my career, I have the luxury of having practiced for a decade or so before the Federal Circuit was founded, and having seen the progression of how patent enforcement was handled. And what has happened over those decades is we put more and more emphasis on the language of the claims and less emphasis on what the invention is. Earlier in my career, we had a robust doctrine of equivalence and reverse doctrine of equivalence, so that you could, in fact, be literally within the language of the claim but not be found to infringe, or be outside the claim and be found to infringe. Markman was adopted, and Markman, while it was well-intended, ends up replacing claims or claim language, which was worked out with the Patent Office, with a district court judge's interpretation of that claim, which interpretation is often ambiguous in different ways than anyone anticipated at the time they were prosecuting. So now you're running your case both as a defendant and as a plaintiff against a new creature that has been created, which is the interpretation, the Markman claim construction. And I'm not sure that any of this is making the system that much better. I think what we're doing is we're finding out that the English language is not that precise and is not capable of that precision, and yet we're placing emphasis on it as if it were. And there's a lot of discussion about it, but
Yeah.
And meanings of words change, and as I understand it, some of the dictionaries are updated by doing surveys of what do you think this word means.
Yeah.
And so you have these problems, but I think if we could find a way to go back and look at, I'll say, what justice would require, we would be better off.
Yeah.
Well, speaking of a lack of precision, perhaps this is a good time to turn to 101. I know, and Phil's going to kick us off with this topic. We have so much to cover in a very short period of time. We're just canvassing all of these incredible issues, and we could talk certainly for an hour and a half about each individual one of them. But maybe start us off, and I know Jonathan also wants to talk a little bit about American Axle too.
Well, I think everyone in the room knows that Section 101 law is a mess. There were 45 witnesses who testified in 2019, and every one of them on, I'll say, both sides of the spectrum, including Mark Lemley. I think Mark Lemley said, it's a mess. And it is a mess. And part of it is because the Supreme Court has thrown out ideas about what they don't think should be eligible. For example, laws of nature. There is not an invention or a product that does not inherently employ or follow laws of nature, gravity, whatever, mechanics. And so if you disqualify based on laws of nature, as one of the decisions, I believe it was Mayo, said it can swallow all of patent law. And we have no real lines. We also have natural phenomena, which is a particular concern, because natural phenomena can, first of all, can be discoveries. I think we've lost sight of the fact that the discovery itself, like discovering the law of gravity, is not an invention. In order to be an invention, you have to have a practical application. And for years, if you look at the MPEP and the way 101 was examined, the focus was on whether there was a credible allegation or showing of a practical utility. And I think we've gotten away from focusing on the utility aspect when we're looking at that. So, for example, if someone finds that there's a correlation between a certain biological compound, an organic compound, in someone who's sick that correlates to their sickness, that to me is not an invention. But if someone can come up with a way of, as they did in Ariosa v. Sequinon, to figure out how to provide a practical application with a practical utility, which in a way which diagnoses, I believe in that case, birth defects, and in a much safer way than before with far fewer miscarriages, then to me that's an invention. And even though it's an invention that relies on a natural phenomenon. Now, why does this matter? This really matters because a lot of, particularly in the life sciences, a lot of our advances begin with basic research where we develop understandings of natural phenomena. And that's often because of NIH funding, government funding, a lot of research foundation funding, some unrestricted corporate giving, but basic research centers do this. But when they come up with a recognition, they may have a hypothesis where they may have very preliminary indications of possible utilities, and we have had an ecosystem where the universities are not in a position to then demonstrate the utility or do what some call proof of principle, but have looked to startup companies or the like who may raise money and do that testing. Well, more recently, with the advent and the expansion of 101 restrictions, the academics have begun to call that Death Valley. Death Valley because the funding isn't there from the startups to do the translational research that's necessary to take it to the next step. Now, these startups don't end up usually carrying a drug or a diagnostic to market because that takes much more, but they are a fundamental part of the ecosystem that is stressed. And the unfortunate thing is Dave Kapos was talking the other day about, do we have enough innovation? Do we need more? How does it feel? Well, the thing about innovation, and particularly in these areas, is you never know what you're missing. You never know if you spent more, whether you would come up with a breakthrough that maybe would, I won't say cure, but allow people to avoid the development of Alzheimer's or other diseases. You don't know. And so when you have a break in the ecosystem, we don't know what we're losing. And it's a shame because I think there's no downside to society were we to have patent protection available for that subject matter.
So I could respond. So one thing I disagree with is that the 101 law is a mess. I actually think it's pretty predictable. I sit here, as an in-house lawyer, and I get all kinds of infringement allegations. I look at patents all day, and I'll tell you that it is way easier to predict how something's going to come out on a 101 challenge or an eligibility challenge versus a general validity challenge, on prior art, or, heaven forbid, like trying to figure out what a claim means. The claim construction issue is the thing that I think that actually drives the uncertainty in 101. It's not 101. I mean, like I said, I think every in-house lawyer can tell you, at least in the computer field, and I'm not saying that's at all true for the life sciences field, what's patentable and what's not under 101. Again, there's some vagueness because sometimes it's unclear what the claim means, but that's really what the debate is. In terms of R&D, again, I'm not speaking for the life sciences area, and I'm very sympathetic with, I read the Federal Circuit cases, and it looks to me like all of the complaints about 101 and, whether or not it's hurting R&D, are in the life sciences field. And so, I'm not an expert on that, and I can't say, maybe we need some sui generis protection there. But with respect to at least the computing fields and every other field, it seems like R&D has not gone down, it's gone up since then. People are still getting massive numbers of patents. We are, IBM is, so I don't think that there's a problem with 101, at least in, maybe the non-life sciences field. And so I just would, caution everybody, I do think we need to address the issues that are there, but that doesn't mean that we need to bring, every other field right along with that. And so, that's just something to think about. The other thing is, there was talk about, whether or not people are resorting to trade secrets instead of patenting because of the 101 problems. And that's not, I don't think that's really the issue, at least in the computing fields. A lot of the reason that trade secrets are chosen instead of patents is because the short-lived nature of patents, which sounds weird, because it is 20 years. But you think about quantum computing and the length of time that it takes, that has taken and will take, to build a real quantum computer, that's over 20 years, right? And so that is a lot of the reason that, we're not choosing necessarily to protect via patent. I don't think it's because of the 101 issues. Again, not speaking for the life sciences industry at all, but I do think we have to think about those things a little bit differently.
Well, I think there certainly are examples where you have issues that are well outside life sciences with 101. When you start talking about truck transmissions and garage door openers not being patentable because of 101, you're clearly not in the life sciences field.
Well, you can certainly get patents on all those things. It's the question of how you claim them. There are plenty of patents on garage doors or plenty of patents on trucking things. Again, those particular claims might have presented an issue.
You know the cases I'm talking about.
I do, and I don't think that there's any lack of R&D in any of those industries.
But that doesn't mean that the patent shouldn't have been allowed on those particular products.
Well, for those reasons. They should not have been allowed for other reasons.
That may be.
Yeah.
Yes.
It's a different issue.
Yeah, well, it's not. So the thing about 101 is that it's historical, and then we should also talk practically about what's going to happen, because there are some things that are going to happen in the next 6 months that most people in this room know about. But basically, 101 was being fought over, particularly after State Street Bank and the way that was written, and the Supreme Court felt, and feel is the right way to put it, that there were issues and patents that were getting granted that were not getting captured by the statutory categories. And in America, we are in our patent law, we are very siloed for each individual ground of rejection, right? It's 101 is here, and then 112 is here, and then 102 is here, and 103 is here. They have different legal standards, they have different briefs, all of this stuff. In Europe, the way that they've approached it for years is super, let's call it practical. They will find that there's an abstract idea in something in an EPO prosecution and say, but there's stuff in there that's not abstract. So now that we've found that there's an abstract idea, we're going to move on to our obviousness analysis. And if you're combining something that is obvious with an abstract idea, well, that's not patentable, right? And most of the 101 cases that have made it up to the Federal Circuit in the non-life sciences space, because I think the natural law exception is a total mess, a totally different thing, are yeah, that shouldn't be patentable, and the judge sees it and says, yeah, that probably shouldn't be patentable because it's obvious or it's combining a known abstract idea with a known product, but I don't have those tools because I can't say in the US patent law under an examiner couldn't either. An examiner couldn't go, yeah, I'm going to combine this abstract idea with this known GPS. You're not allowed to do that. I tried to do that when I was an examiner. They say, no, you got to have a document that you're combining it with, right? So, I even went back to try to find a basic textbooks that said, this is the document I'm combining it with, this is the abstract concept. And, oh, no, you can't do that. So, so that was the pathway leading up to Alice, and there was a lot of attention on it, and there was a lot of confusion. Clearly, the Federal Circuit couldn't decide, and we're at cross purposes, and we had Judge Rader giving additional views on top of his original thing, and there was all this attention. And in the oral argument, the government was basically saying, we already have the CBM standard, which is effectively the European standard. A technological means is attached to it, it drops out, and it was all presented with a nice bow to the Supreme Court. And Justice Breyer, who was a wonderful jurist, and his heart was in the right place, comes up with an entirely new way to categorize it, an entirely new way to analyze it, and that is what has, let's say, offended the senses, because I think there are judges seeing patents that they know shouldn't have been patentable for the reasons I said earlier, but don't have those tools and don't see a path to those tools, and so they canceled the patent under what they've been given. That bothers everybody, right? So we've had years of talking about, and so to go to the practical side of this politically, we've been talking for years about some sort of legislative reform. And there was an effort that basically hit a wall hard, right, under the last administration. And I think people are once bitten, twice shy, and are afraid to even approach that. But they have continued to try to get the same Supreme Court that put us in this position to fix it. And it's a different court a little bit, but it's still the Supreme Court. We're now in a position where we are waiting on a CVSG, a call for the solicitor's views, in a case called American Axle, which is the case kind of we're all talking about, where there's a garage door opener or a carburetor. I think this was the carburetor case.
Truck axle.
Truck axle.
Truck axle, where there's a mechanical part attached to the claim. So everyone's like, come on, there's a mechanical part. And in full disclosure, outside of my work at Unified, I joined Adam Mossoff's brief at the federal circuit level. I think this was clearly something that you can just say, there's a mechanical thing attached to it, it shouldn't be under 101. I do think that they should amend the laws to say it should be under 103, but I think intellectually, fine, right? They have been sitting on that CVSG for practical purposes until the new director is sat so that she can attend the meetings where everybody gets together and then attempts yet again, which is something that happened under Director Iancu with the last big case that didn't get granted cert, to sort of make the case in the solicitor's brief that the time is ripe and that we're going to look at this again and that the Supreme Court should fix this. I have very little confidence that what the Supreme Court does, well, I have very little confidence that I have any idea what the Supreme Court will do. I'll put it that way. They could fix it. They could destroy it even more. They could make it worse or they could make it better. But I don't think any of us have any control over that. So I think we are kind of setting ourselves up as an industry, let's call it, because patent litigation is an industry, we call it that we might have another Supreme Court case that we can complain about for another 10 or 15 years,
Yeah.
which will keep us all in jobs, but I don't think it's gonna make things any clearer. But that's kind of, I think, practically where we are right now. I think Director Vidal will sit in those meetings will happen, they will move for CVSG, the solicitor's office will write a wonderful brief, there's higher likelihood now than ever before that they will relook at Alice. What that means to anyone is anybody's guess.
Yeah, but I do actually want to get to another point that, I mean, I do think you're right. There's a lot of, we lawyers love to talk about, what was the theory on which this thing was invalid or that thing's invalid. And, that's all important to us. But frankly, that's not that important to most innovators. And that's who we're trying to serve. We're trying to serve the innovators. And I'll tell you, most engineers, they read a patent, they don't know what it means. And they don't know how it's invalid, but it's invalid to them. And I don't think anyone thinks that any of these patents have been invalidated. Again, life sciences accepted, that there's some sort of tragedy there. The innovation is still occurring, and whether or not we invalidate on one theory or another, and again, in Europe, it's a little bit more blended, so you don't have as much of this debate about whether that decision was right or wrong. They ended up with the right result. Again, I know that we all love the theory, and it's important. I'm not saying it's not important at all, but if you look at, you just have to look at the top level. We're here to talk about innovation, and I think the system is a little bit failing the innovators, because they're the people who are supposed to be able to read this stuff.
The way I would put that is I think that the legislative attempt, that was, let's call it abortive because it didn't even get introduced, collapsed under the weight of the lawyers caring more about the words and the way that it was written and the theory than about what it was going to accomplish. And the legislator, that's a death knell to trying to pass esoteric legislation in the first place, right? And so the people involved who were very involved and very interested just threw up their hands and said, we're just not going to do this because we can't be here to fix sort of esoteric legal theories when, it seems to be kind of working for district court judges and kind of working for getting to a result that's not the worst result, because most people agree that a lot of these patents probably shouldn't have been patented in a different way. And it's just hard to get legislators.
They couldn't get consensus, and they don't pass anything without consensus.
Exactly.
That's all.
Right.
Kristen, we'll go to you. We have about 13 minutes left, and we still haven't talked about
Well, shoot, I wanted to talk about 101, but okay.
Well, do you want, so go to you to talk about 101 briefly, and then let's talk about COVID waivers and the
Yeah,
ads
yeah.
at bus stops that say things like patents
Oh,
killed.
dear God. Okay. So just quickly, I don't disagree at all with anything that's been said about 101, but I think the opportunity we're missing by using 101 as a shorthand to get rid of patents that otherwise are invalid for other reasons, 102, 103, 112, is we're actually failing in the development of 102, 103, 112 then. Like we are letting opportunities to clear up obviousness lapse because we are being lazy and saying, oh, well, 101. So I do think there's more here than just are people still throwing money into these fields. I think there's legal development that's falling by the wayside, and I can say that because I'm a law professor and I think about things with no real attachment. So, okay, so the COVID waiver. We all know that vaccines are amazing. It's wonderful. It's why we're here today. IP made some of these COVID vaccines possible. These vaccines feel like, and people oftentimes talk like they were an overnight success, right? Like, oh my gosh, COVID came and then all of a sudden we had vaccines and wasn't that amazing? But the underlying research of particularly the mRNA, but all vaccine research goes back, decades, or at least a decade for the mRNA stuff. And so this is this underlying research that's expensive. A lot of it's government funded. It's not all government funded. And so IP does indeed make a lot of these technologies that are very exciting to us happen. So what happened, just in case you weren't following it, in 2020, India and South Africa requested of the WTO a waiver for COVID-related IP. And so the thing is under the WTO, there's an international obligation to respect patent rights. And I'm shorthanding this a lot here because I have like zero time. And so the idea is that it would allow countries to not respect those obligations with respect to COVID IP again. And the idea is let's get more people vaccinated. And more vaccinations is more better, and we are all wanting all of that. Now, TRIPS already has a compulsory licensing provision, and so there was a lot of questions about, well, why couldn't this just be done with the compulsory licensing? Why do we have to go and ask instead for a COVID waiver? We also have a number of patentees that had already independently waived. They just said, we are not going to enforce our COVID-related. George and Mark Lemley had a pledge program that companies could agree that they also, George, I won't steal your story, but so there was a lot of things happening outside of this request for the waiver, which again makes you wonder what was the deal with this waiver. The waiver is still happening. It's still being negotiated. Very recently, there's some sticking points, pun intended, vaccine shots, it's good. So the real issues have less to do with the IP and more to do with, is this going to make any difference? So patents kill, no they don't. Patents have never killed anybody. But a couple of things. So first of all, there is a disagreement, and part of the sticking points in the discussions right now is it a waiver as to patents only, or is it a waiver as to know-how? And so this gets to the trade secret issue that Bob was talking about earlier. The problem with waiving of IP rights with respect to trade secrets is this. If you waive your patent rights, okay, fine, don't need to respect them for 3 years, 5 years, that's another thing, how long is this waiver gonna last for, but 3 years, 5 years, however long. Okay, and then when that 5 years is up, you get to enforce your patent again. The problem with trade secrets is what happens, right? That it's not a trade secret anymore, right? So if you give up your trade secret rights with respect to some of these technologies, that means you have to share the information with the world, and you can't put that toothpaste back in the tube, and you lose a lot more. And so a lot of these technologies, there's the patent that covers them, but there's also the know-how that goes along with it. And so one of the negotiations that's been ongoing with respect to the waiver is it just patents, or is it patents plus know-how? You can imagine the pharmaceutical companies are not terribly excited about giving away their trade secrets. even if they are very willing to allow for their patents. So there's questions about the trade secret. There's also questions about, is this even the problem, right? If we have the pledges, if we have the waivers, is that actually going to increase the ability to get vaccines to the places where they're most needed, where people aren't vaccinated at the same rate as the United States? And the problem there might also be manufacturing capabilities, distribution capabilities, infrastructure capabilities, political issues, right? The COVID waiver doesn't solve any of those, so if we end up and we have this big pile of vaccines but no way to get them into people's arms, has the COVID waiver done anything? And so the United States, through their trade rep, signaled that they were okay with the waiver last spring. European countries have been much slower to be willing to agree to the waiver, not surprisingly, because a lot of big pharmaceutical companies are in Europe. It's still under a lot of negotiation. It's expected to go forward in some way, shape, or form, probably a short waiver, probably only with respect to patents. And then the question is, why are we doing this and what good does it do? So I will stop there.
Bob?
I would say real quickly, I agree with everything you said. I believe the United States traded this in order to curry favor with India. I think that they recognize the WTO can't agree for a time for lunch. And I don't think you're going to find that all of the nations are going to agree to this TRIPS waiver, so it's not going to ever go really into effect.
Right.
And I'm not sure with the way India has been not helping us with Russia that we're going to be as interested in moving forward with it at all either.
True.
That's it.
So,
Phil and then Jonathan?
well, his is going to be way more interesting and way more so I just want to give a quick outsider's perspective of the practical implications. I have no dog in the fight, but I think that this is like the pharmaceutical industry has had, there are provisions in other areas of the law domestically in the US about compulsory licensing, and there are provisions in other treaties about compulsory licensing, and the historical line amongst the pharmaceutical industry has been even an official looking in the direction of those things is met with an insane amount of lobbying and an insane amount of effort to push them away, because even the suggestion or threat that there might ever be march-in rights or compulsory licensing for medicines is sort of like this bulwark. We never want to get there because it could destroy an entire company, it could destroy an entire industry. Senators right now on the Hill are suggesting that they will use the march-in rights to affect drug rights and other things, and so I think there's a bigger fight that the pharmaceutical industry has in their hands, but it has generated a massive amount of, I'm just trying to put it in perspective for the students, a massive amount of lobbying over a trade rep suggesting that they wouldn't oppose something that an international body does that it probably won't do anyways, that doesn't actually necessarily change what's happening.
Anything.
And the reason is because it would be the first time that the US central government basically has taken a position that was sort of like, yeah, there are some instances, some very extreme instances where we think march-in rights are okay. And you could go back to Bush era Tamiflu. There was a period where we were running out of Tamiflu and Bush was like, I think he had one of his officials say, we're thinking about it in like one meeting, and the industry like flipped out and made all this Tamiflu so that they wouldn't even talk about it, right? Because it represents a very serious threat. If the government decided, which it could, that it would basically say, to ease a drug shortage, your rights don't apply and we're not going to pay you, it looks like the nationalization of that patent right, and it scares people. That's all. Context. I don't have a dog in the fight.
We have about 5 minutes.
Okay.
So Phil,
I'd
Megan,
just like to point out, this isn't the first time that we have had situations where serious disease and getting medications to treat serious disease around the world has been a problem. And I'll relate my experience that I know from Johnson & Johnson was when AIDS was less well controlled, especially in sub-Saharan Africa and the least developed parts of the world. And J&J had a number of effective AIDS drugs. That a problem was that there was not available resources to provide those drugs in the least developed world. They were being manufactured in Europe. They were expensive. So J&J adopted the policy of looking for a lower cost supplier and needed its patents in order to get Indian drug companies interested in becoming a second source of supply, and licensed them so that they could lower the dead net cost of the drugs. That proved to be effective in providing more drugs to sub-Saharan Africa, but not enough drugs to sub-Saharan Africa. And the question was raised, are patents a problem? J&J, and there is a problem, well, I'll go into that, but, so the question arose, and J&J decided that because of the lack of drugs and because of the argument that more drugs would be available without patents, they announced that they would not enforce any patent protection in the least developed countries, and there was a list of the least developed countries, unless the drugs that were being supplied did not meet the minimum WHO standards for an effective drug. And so that they decided to use their patent protection to keep bad drugs off the market. And because if you are dealing with resistance, the worst thing you can do is have an ineffective drug be given that doesn't solve the problem and only allows mutation of the virus so that other drugs that are effective will become less effective. And that was a way that this was approached. And unfortunately, I can't say it really helped that much, because there in fact weren't other sources of supply. It became a funding issue, and there were other ways that they addressed it, which was basically to get more funding to be able to buy the Indian source drugs that were the cheapest ones. I'd also note, just in passing, that when it comes to COVID, J&J announced from the get-go that that the vaccine that it was going to make and sell, it would sell at cost, and it still is selling that at cost. And the reason that that vaccine exists is because J&J, in combination with the Gates Foundation, was working on Ebola vaccines. Ebola is not a very big problem, but there's a concern. And so it was the technology from working on Ebola vaccines that they adapted to use for the COVID. So it's not all lobbying and going for money. There are people in the pharmaceutical industry who are worried about human health and have dedicated themselves to try to improve it.
Yeah, I don't mean to be glib. Obviously, there are very rational and well-developed arguments, both for and against it, and I would say any compulsory licensing should be done, if it's ever done, very judiciously and very carefully, because you are basically saying that, you know, one hand giveth, one hand taketh away. If the government grants the patents, they could take them back at any point, but if you do that and people can't rely on them, then, you know.
I mean,
Right.
millions and millions of dollars have gone into the Moderna development
Right.
over a course of 10 years or more. And the last thing you want to do is create an object lesson that was a bad idea.
Well, the interesting thing about sorry. Yeah, go ahead.
We're just about running out of time, so we could keep going forever on this, but I do want Isabella to take us out now on with some comments. When we were brainstorming topics, I was delighted that she suggested we talk about STEM and young people in innovation, which brings us kind of full circle from where we began today in an appropriate kind of leaving note. So if you could make your comments, then we will include those, and then we'll wrap up.
Okay. All right. Well, thank you. I thought we were going to be out of time, but I won't go over all the things that I think not just my company, but a lot of other companies are doing to try to encourage STEM education and try to encourage, among among girls, among women, among underrepresented minorities. We have lots and lots of skilling initiatives that are free on LinkedIn and Microsoft.com. But I think it's really, really important for us to recognize the magnitude of this problem. Cybersecurity is a huge issue. I'll just pick one issue. Cybersecurity is a huge issue. We are at a gap in the United States in filling those jobs. 1/3 of those jobs, if we sort of project out what we're going to need and how many people are skilled in those jobs, 1/3 of those jobs are not going to be filled. And so Microsoft, and I think some other companies are participating as well, has a lot of, free education on this to try to get people, and we're targeting a lot of underrepresented communities to try to get their skills up so they can not only get, well-paying jobs, but also fill these gaps. Another thing that Microsoft and a lot of other companies are doing is really trying to encourage inventor diversity. The USPTO, obviously, because of the Success Act and other initiatives, is really trying to spur greater inventorship among diverse communities, and it's been a struggle. A lot of that is access in terms of learning, like what the patent process is about, but also access to lawyers. And a number of companies, including Microsoft, have undertaken a pledge to really improve even our own internal inventor diversity. And so we have metrics that we're measuring against and trying to succeed in. And I think that one of the things that is really important in that also, and for this audience that's in law school or looking at law school, is we do need to have a lot of diverse lawyers representing these folks. I mean, I've heard some of the congressional testimony from some of the inventors, from like SheFly and Spanx, and a lot of them say that they just didn't even know where to get a lawyer. Every lawyer they talked to was a man and didn't understand their product. And I don't think that's, I don't think we necessarily, plenty of us are happy to talk to, a white male lawyer, but I do think that there is also an appreciation for technology and the use of that technology that goes missing if we don't have people in these fields, all the fields, both in the patenting field as well as, just knowledgeable about the technology, that don't represent all the diverse perspectives in the world. And so I know we're short on time, so I won't go through all the things that we've done, but one of the things that Microsoft has done that I'm especially proud of is our Make What's Next patent program. We launched it in 2016. It is geared primarily towards, the educational market. We file a lot of patents on behalf of high school kids and colleges, primarily, targeted at women, but and it's all pro bono, so maybe your son could get one of these patents. But we've filed, I think we've got over 50 invention ideas. We've filed 24 applications. We've gotten 15 patents granted, and you should just see the delight of all of the teachers and all of the students when when we file the patent, but also when they're granted a patent. I mean, one of the towns that with a high school where we got a patent, they had a huge celebration. And I think it's a way of just getting kids and young people excited about a career in innovation and science. And so we're always happy to have other people help us out with these things. And I just want to encourage everybody to play a part in this, because just seeing these inventors and seeing these young people really excited about things really makes you excited about your job, more so than all the fighting that we do every single day on all the commercial interests. So,
thank you, and thanks to all of you for participating today. Let's give everyone a round of applause.